We're now in a world where there's a huge movement post-COVID of we don't want the government telling us what to do. We don't want the government infringing on our rights. But for the last 20 years, we have allowed our legislature to infringe on our rights as patients and in general as victims of negligence by grants of immunity to special interest groups and by making it harder to have access to the courts by lowering the jury threshold.
Yep.
It now, instead of taking less than a year to get a trial, it takes a year or 2 or 3 to get a trial in a medical malpractice cases because the trial dockets are full of $15,000 car wreck cases.
Baton Rouge is insane. I mean, where you practice, I have a few in Baton Rouge. I mean, 2 years easily once you get to the judicial setting.
And I can't recall who coined the phrase, but justice delayed is justice denied.
Welcome to Bayou Justice, Breaking Victims, Protecting Power. I'm your host, Chip Wagar, a medical malpractice attorney dedicated to reforming Louisiana's healthcare laws. On this show, we dive deep into the challenges faced by patients in our state, exploring how current laws often favor institutions over individuals. Each episode will bring you compelling stories from victims, insights from legal experts, and perspectives from lawmakers. Join us as we work to shed light on these issues and push for meaningful change in the Bayou State.
Good afternoon. Thanks for joining me. My name's SARAH WAGAR HICKMAN, and this is Bayou Justice, Breaking Victims, Protecting Power. Today, we have one of my very good colleagues on the podcast. His name is Ben Mouton. Ben is an accomplished trial lawyer, and he's based in Baton Rouge, Louisiana. He is one of the founding partners of MGM Injury Attorneys. He has extensive experience in handling complex litigation, especially and including medical malpractice, which we'll be talking about today. And he is known for his meticulous approach to litigation, and he's really just revered throughout our community, a leader in our LAJ section for MedMal, and just someone the community, MedMal community really just looks up to. So we're really glad to have you on the show, Ben.
Thank you for having me, Sarah.
Today, the theme of our podcast is justice on trial, fighting for victims in a broken system. So there's a lot to talk about there, right?
For sure.
Just curious, because I've known you for years. How did you get your first MedMal case?
So without going into too much detail, my boss, when I was a young lawyer in Baton Rouge, has a brother in Shreveport who was by himself, had been doing medical malpractice on the plaintiff side of these cases for many years and needed some soldiers. So myself and 2 other associates here in Baton Rouge would go regularly up to Shreveport and work on cases. And because I was the youngest and least experienced, I started out screening cases and then handling them through the medical review panel and then following them through to resolution either by settlement or by trial on the merits. If it's okay, I would like to mention his name. It's Edmund Thomas. He goes by Ted. So Ted Thomas, for purposes of teaching me the ins and outs and the good and the bad of medical malpractice litigation, I tip my hat to him. He's still around. He's retired in Shreveport. And we just settled a case he had referred to me years ago. So
that's awesome that he's still around. I've heard of him. I'm a relatively newcomer to medical malpractice, only a decade here, but you must have liked medical malpractice, and that says something unique about you because it's a very difficult area of the law, right?
There's no doubt. And what I was always told and what is true even today, all of these cases are very interesting. I've got a science-based mind. I've been able to retain a lot of medicine that I've had to learn to take depositions and cross-examine witnesses. But it does make every case interesting. I've been doing this for over 40 years, almost 40 years, and I've not had really a lot of cases that are completely identical. There's always a wrinkle or two with each case.
That's so true. I started my career practicing in personal injury defense, and everything was exactly this. I mean, the injuries aren't identical. I don't mean to downplay that, but the discovery, everything you did was just, routine. And then when I got exposed to medical malpractice, I thought, this is how you keep learning. This is how you keep growing. And it sucked me in. So I can relate there. But the law is the really makes medical malpractice a very tough area to practice in. Can you just explain a little bit about why that is generally?
Well, yeah, going back 50 years in 1975, medical malpractice cases were handled like any other personal injury case. You filed a lawsuit, you did discovery, you retained experts. When the case was ready for trial, it got set for trial and was tried. If it was not resolved by settlement, it was treated just like any other personal injury case. But
in that year, happened. Yes, what happened?
In that year, the legislature, relying on what had happened in the state of Indiana a year prior, decided that they wanted to completely revamp how medical malpractice cases would be handled from filing all the way through resolution. And they created a medical review panel. They capped damages in 1975. All damages of any kind, general and special damages, were capped at $500,000. I was 10 at the time, so I have no idea whether this is true, but they said back then there had never been a malpractice verdict in excess of $500,000, and that's where they got the cap from, which at that time made sense. Right?
Which also begs the question, though, if it had never gone over $500,000, why would you need the cap?
Exactly.
Throwing that out there. Yeah.
And in the last year, we've had a 10, a 12, and a $14 million jury verdict in different parishes under different circumstances with different facts. And so the $500,000 cap, just by that example alone is woefully inadequate. But go ahead.
And no, I was going to say, and Louisiana is unique too. Other states have caps, and they allow for economic damages. And for anyone that's watching that doesn't know what I mean, say you're 35 years old, you make $100,000 a year, you're the breadwinner of your family, and you're injured in a surgery and you have a brain injury, you can't work. So they would be able to recover for their life expectancy, that $100,000, for the rest of their work life.
Absolutely. Or if that patient were to die, their family could recover that unlimited.
Absolutely.
Not unlimited, but uncapped.
Uncapped. But in Louisiana, you can't do that. That's not allowed. That's under the $500,000.
Correct.
Which is
in 1984, one change was made to the Medical Malpractice Act, and that was they basically excluded past and future medical expenses from the cap, but kept other economic damages within the cap.
Now, yeah, and you touched on something that I want to come back to, and that being the future medical damages, because that's a whole nother area of the statute that's really troubling and makes our practice very difficult and makes it difficult for victims to be made whole. But I want to talk to you a little bit about, you mentioned the panel system that was put in place in 1975. Talk a little bit about what that is and why, even if their intentions were wonderful, why it's just not working.
Well, it's a system that I think on paper sounds like it would be a fair system. When a claim is filed, it's not a lawsuit. It's a request for medical review panel or a petition for medical review panel. The claimant gets to pick the first doctor to serve on the panel. That doctor has to be licensed in Louisiana and generally in the same specialty as the defendant.
Right.
the defendant gets to pick the second doctor, or collectively the defendants do, and then those two are asked to pick a third to serve on the panel. And so you end up with three doctors that are reviewing the care of either one doctor or multiple doctors and other healthcare providers. And it is nothing more than peer review. It's doctors reviewing care provided to patients by their peers. And they know that there's implications if they find fault or substandard care. It kind of sets the bar for them and their own partners in their own practice. And I think that that's the driving force behind a very lenient, not lenient, situation with panel opinions. They tend to, statistically over time, it's been overwhelmingly in favor of healthcare providers.
Absolutely. And I want to drive home a point that you made that may have gone unnoticed. These panels, they're not anonymous, are they? Like these three doctors, they don't get to decide behind a closed door, something with some protection so they can speak freely and exchange their true feelings. They don't get to do that.
Their deliberations are private.
That's
we get
true.
to visit with them before, and we get to visit with them after the opinion is reached. So I think it's set up to encourage those who want to speak freely. But it's, we don't know what happens, and the attorney chair who's appointed to administer this process is generally not called upon to give any testimony. It's just the doctors, and they get to talk about their opinions in the case. I will say, though, more recently, we've had split opinions. We've had some independent thinkers that are willing to say, I don't believe that the standard of care was met, and I'm going to have my own opinion. We encourage them to do that when we argue the case to them, and I think that that's starting to pay dividends. But generally, it's a 3-0 for or 3-0 against, and that's a huge hurdle to get past in improving the case for your client.
It is. It certainly is. And for the doctors that are on that panel, just to put it one more way, the doctor that they're reviewing the care of could be on their panel the next week.
Correct.
I mean, that's a hypothetical, of course, but that's how the system is, probably unintentionally, but that's how it's set up, right?
Yeah. I mean, look, if you're limited to only Louisiana licensed physicians, there's a finite number of physicians that can serve on a panel.
Right.
Obviously, in something like primary care, there are more doctors in that specialty to choose from.
Right.
But if you get into something super specialized like neurosurgery, spine surgery,
cardiothoracic.
You're dealing with a very small subset of physicians that are qualified to serve on that panel. And they do tend to serve on each other's panels or serve as experts on each other's claims. And so that's it's unavoidable, unfortunately, but it is patently unfair.
And that's my point. When we get a negative panel, which, to be honest, like you've said recently, I think there's been a trend. I think I've seen some better outcomes than the 97% that it used to sit at that favored the doctor. But I would say when I do face a panelist during trial, I almost always make it a point to ask him that it would be very awkward to have to look at his colleague and tell him that he believed he committed malpractice. And
Sure.
They really have trouble answering that one. Either they go for the, oh no, it wouldn't be awkward at all, which a jury looks at and goes, or they say, yeah, it is awkward, Right. So it's a tough position for them to be in, to be honest.
Yeah. And they get paid a whopping $300 total for their service.
Yeah.
And so there's not this huge incentive to invest a lot of time. They have to do it because they're challenged by the task and challenged by the trying to forensically figure out what happened in this patient's care and call the shots the way they think they should be called. But most of them, it's not the most important thing in their day or their week or their month. And you know, it I think shows in some instances, not all for sure.
Yeah, I completely agree. And I've never thought of it this way until you said that. But when a panel opinion comes out and it's, 3-0 against the victim, it automatically comes into evidence. That's, of course, if it's not struck from evidence for some evidentiary reason, there's some ruling against it. It automatically comes in by law, right?
Yes, and it's given the weight and the authority of an expert opinion. So it is the only expert opinion that goes that goes into evidence and can be actually picked up, held, and read and reviewed by the jury in the deliberation room. All the other opinions that they'll get in the case are either presented verbally from the witness stand in the trial, right, or via deposition, either read to them or showed by video. And they can ask for, but will not get those transcripts. They have to take notes during those testimonies and recall what the testimony was.
And the other point that came to my mind, and it's in my experience, a lot of times they end up coming to their final conclusions based on factually incorrect information that, as a seasoned attorney, a cross-examiner, you can pull out of them on the stand and get them to admit, well, yeah, that's not quite true. But it's not often that an expert on a panel is going to turn around and flip on the stand, right? So they don't have the incentive to spend so much time meticulously going through a case. They render an opinion and it comes in regardless, Yep. It's just a big strike that happens right away, and usually not in favor of the plaintiff.
Yeah, and I know we're going to probably talk a little bit about the concept of frivolous lawsuits. But let me just say this right now. A medical malpractice case goes to trial, okay? If it's going to be presented to a jury, the plaintiff will have to have one or more experts that are qualified by their education, training, and experience to lay out what the standard of care is, whether it was breached or not, and what the consequences of not following the standard of care was for this patient or the decedent in the case. Likewise, if the case goes to trial, the defense is going to have an expert or two.
Absolutely.
That essentially meets the qualifications and experience and training of the plaintiff's experts. And so you have the proverbial battle of the experts. And I am convinced, after trying cases that I thought I would win and losing,
been there,
and speaking to jurors after, this panel opinion, which is the only opinion they get to actually show to their fellow jurors and highlight language in it for them, is the tiebreaker. Well, plaintiff's expert said this, defense expert said this. What do these guys have to say about the case? And so it's probably the biggest hurdle to winning a case. And I think the results would favor plaintiffs, statistically more if that didn't go into evidence. They could still come and say what their opinion was. But if their opinion didn't go into evidence, that would be huge, at least leveling the playing field, in my opinion.
Agree. You and I think, are both of the minds that the medical review panel system should be done away with as a whole, but certainly it would help if it wasn't admitted into evidence.
Correct.
You brought up frivolous lawsuits. And we live in a state that has just gone through a legislative session and seen the commercials about tort reform and how lawyers are at least a piece of what's causing all of our homeowners and car, auto insurance rates to rise, medical insurance rates to rise. We've just gone through all that. And one of the things that gets thrown around a lot is that we're the most litigious state in the country, and that we file frivolous lawsuits. I want to talk specifically about medical malpractice. Given what you've just told me about the expense, because you have to pay the expert that is going to testify for you, and guide you really through the litigation. We're not doctors. Why is it that you don't see that many frivolous medical malpractice lawsuits?
Well, because we would bankrupt our law firms 3 times, 4 times over if we pursued frivolous lawsuits. Frivolous lawsuits, and again, you have to, one of the problems in this discussion is what's that, what is the definition of it?
Yeah.
What does it mean? Okay, because I think if you ask 10 people, you may get 10 different answers.
I think you're right.
Okay? A frivolous lawsuit would be one that's based on fraud, and there are criminal statutes and that can be pursued against someone who's committing a fraud and trying to bring a frivolous lawsuit. Okay? But frivolous doesn't mean a case that was tried on the merits and lost. That doesn't make it frivolous. Okay?
Absolutely.
Just like if we win a case and the defense offered a defense to the case that was not accepted by the jury, it doesn't make that defense frivolous. It was just not successful in that particular case with that particular jury.
Right.
So I think, I will be honest, I think that because medical review panel requests can be filed in proper person, meaning by the patient themselves or by the family of the patient without a lawyer, there are probably technically some frivolous claims that are brought to the medical review panel. But through that screening process and the resulting opinion that would come out of it, I think that will screen those out. And no lawyer who is in business, who has a reputation, is going to take a frivolous lawsuit with the belief that, I'll just bring the claim and they'll settle with me quickly to avoid, the cost or whatever. That's just not something we deal with in medical malpractice.
And I was about to say, medical malpractice cases don't generally settle at the rates that other personal injury cases settle at. And some of that has to do with the law itself. And I'm not claiming this is a bad part of the law, it just is. The underlying healthcare provider is only responsible for the first $100,000 of damage. So if you've got a huge case that the damages, well, they're capped at 500,000, but let's say in a different world would be in the millions. They have no incentive to settle that case if all they can lose is 100,000, right?
Correct. Yeah. I mean, I think that, it's their liability. So I guess the entire amount of that liability gets assigned to them if it is settled or if it goes to trial and the judgment is satisfied. But yeah, they have insurance that is generally affordable and available. And we have doctors that are so comfortable with the environment, they self-insure for the 100,000.
Absolutely.
And that's telling to me that, yes, doctors make money and doctor clinics generate a lot of income, but to go and say, I don't even need to buy insurance because of the system that we have, right, appreciating what their real risk is telling to me. So I think that's part of it. And the other part of it is the law favors the defense in these cases. We have the burden of proof. These cases can be very, very difficult to put in simple terms. Oh, yeah. And so sometimes you can have a beautifully presented case, but 9 or more of the jurors are not clear on, what the issue is and where the mistake was. Right. Look, we all drive cars. We've been driving cars since we were 15 or 16 years old. Okay. Everybody knows the rules of the road. or most of them at least.
Yeah.
And so it's easier to be a juror on an auto accident case because you have your own experiences to draw from, right?
Absolutely. I think that's what makes the medical review panel decision another devastating again, because when jurors' first reaction in voir dire, when you're speaking to them and you actually get to converse with them, when they first figure out that this is a medical malpractice case, how many times have you heard, I'm not a doctor. How am I going to judge that? And especially when the defense stands up and says, this has gone through a medical review panel, and you'll get to see their independent decision. I think for a lot of Louisiana jurors, it ends right there. You can stop.
Yeah, and the fact that the defendant is a doctor and can be accepted as an expert in the case.
Absolutely.
So you end up with, and that's an unfair fight because the plaintiff is not a doctor.
No, and usually they're unconscious, dead, or have no idea what happened to them. Even if they were awake, they don't know,
Right.
So
there's an advantage there. At least in a car wreck case, both are drivers, right? And both sort of stand on equal footing in terms of what they did or didn't do under the circumstances that they encountered. But here, there's this strong desire to defer to doctors. We all have a primary care doctor. Yeah. Right. We've all had a doctor deliver our babies,
right.
Take care of our babies and our young children as they grow up. And most people have a very good relationship with their doctor. And so that bias is built into all of us.
I agree. I get asked all the time when people find out what I do, oh, you must have a real troublesome relationship with doctors. And I always say, no, not at all. I couldn't do what I do without a doctor. I need a doctor to guide me, to tell me this is malpractice, this is why, and help me help my client, and thank God for doctors that do that. Also, I have wonderful experience. Most doctors, they may make a mistake or so in their career. We're human. To err is human. But when the results of those accidents or negligent behavior is catastrophic or deadly, that's what we're here for, So,
that's right.
To talk about what's coming down the pipe, we've just finished the 2025 are finishing the 2025 legislative session. And we'd like to make a push in 2026 to raise the cap. Now, that's that $500,000 cap that we've been talking about. And
sure.
What would that look like today? Do you know, just roughly in today's dollars? What do you know what the cap would be?
Yeah, I mean, the way I've always looked at it is the effect of inflation. That $500,000 in 1976, which is the year it became effective,
right,
is worth somewhere in the $120,000 to $140,000 range. Well, you got to have good math skills to flip that around to know how much the cap would need to be. But it's about a it's about an 80% impact. So if you want to make up for it, you would have to apply that to the $500,000, and it would be somewhere in the $2.5 million range, I would think. And what was never done before is have an inflationary bump or reduction if necessary. It has to be fair. It has to be both ways.
Yes.
But bump it up every year or two to keep up with inflation. Everything else is impacted by inflation, and adjustments are made. Wages are adjusted over time to deal with inflation. Healthcare costs have been skyrocketing because of inflation. Our car insurance is what I'm being told is going up because of the inflationary effect on parts and labor to fix cars that get in wrecks.
Right.
And so, it's not novel. It should have been done long ago, and it needs to be done even if we raise the cap or adjust the cap, as I like to say.
Yeah, I like adjust too. Over the weekend, I was having a conversation with one of our mutual friends and colleagues. Shout out to Scott Weber on this. But he made the point of, and I thought it was brilliant, who are we to question the legislature's decision in 1975 to limit the damages at $500,000? I mean, that they thought that was fair in 1975, right? I mean,
that's right.
I mean, so who are we to even question that? But the same rationale rings true today then. You can't bring in 2025 profits, but have a cap still in $1975, right?
Right.
I mean, this is just common sense.
Exactly. And look, the point that needs to be made is not every medical malpractice case has catastrophic damages or permanent medical needs. Some, the person does make a recovery, and they are capable of getting full
and fair
and adequate compensation, even with the cap as is.
Yeah.
What this cap has done over the last 50 years, because it hasn't ever been adjusted up, is it punishes the victims and their families who are injured the worst.
Yeah.
Okay. The hypothetical you gave of the 30-year-old who makes $100,000 a year. Yeah. I mean, they're basically, without getting a dollar for their pain and suffering or their disability, the cap allows them basically to say, we'll give you 5 years of your lost income. Good luck.
Yeah.
Right. And so we have to, we have to champion the fact that it's the worst cases that are getting punished.
Absolutely.
And prejudiced by this cap. Not every case, but the worst that need the compensation more than others. And what it does is it puts people on the Medicaid rolls of the state of Louisiana that didn't need to be there and wouldn't need to be there if the compensation was adequate.
I was just about to go there. In Louisiana, and I think we're a state that prides ourselves on, if you can work, you should work. If you can possibly be out there, get out there and do something. These are people that have been injured, are deemed to not be able to work, and someone's been found liable for it, but the Louisiana taxpayer is now paying for really the majority of their medical bills and any other handouts that they get. And that's not fair to taxpayers.
Correct.
Yeah.
Correct. Look, we're now in a world where there's a huge movement post-COVID of we don't want the government telling us what to do. We don't want the government infringing on our rights. But for the last 20 years, we have allowed our legislature to infringe on our rights as patients and in general as victims of negligence by grants of immunity to special interest groups. And by making it harder to have access to the courts by lowering the jury threshold.
Yeah.
It now, instead of taking less than a year to get a trial, it takes a year or 2 or 3 to get a trial in a medical malpractice cases because the trial dockets are full of $15,000 car wreck cases.
Baton Rouge is insane. I mean, where you practice, I have a few in Baton Rouge, and 2 years easily once you get to the judicial setting, So,
and I can't recall who coined the phrase, but justice delayed is justice denied.
100%. And you and I have spent some time together recently at the legislature. We went to session together to oppose a bill, the nursing home bill, or the Bob Dean Protection Act. But a slew of tort reform has just been passed in Louisiana. What are your comments about that? I mean, it doesn't affect medical malpractice specifically. We were carved out even of luckily and rightfully out of a couple bills. But what do you think? What do you think the thought is behind this? We've been at it for 15 years and rates aren't lowering.
Right. I think the challenge was made this year and in previous years. We'll do this, but insurance companies, let's put in the law that you shall reduce rates by 20%, 25%.
Yes.
The last wave, we had an insurance commissioner who testified in committee and guaranteed essentially a 25% reduction in rates if all of this was passed. It was passed. It was amended. It was probably not in the exact posture that he was in favor of, but a lot, if not all of it passed. And it didn't work. And we predicted it wouldn't work because things other than lawsuits and payouts of claims are driving rates.
That's right.
And until and unless you accept that, you're never going to accomplish what people want. But people are fed up with paying the premiums that we're paying.
I am. Yeah, same. I'm going to sell a kidney, I mean, like my house, my property insurance, it's like every year I like get the envelope and I'm just dreading opening it, and my house is never flooded. I've never made a claim. So it's, it's predatory is what it is. And we've got to get serious. I mean, we can talk about tort reform and they've been doing it for 15 years. And I hope the public realizes after 15 years of this, they've stripped away rights and nothing's changed. We need to get serious about regulating insurance and bringing them to the table because that's what's driving the increased rates. I think that's what the data shows at this point. Now,
I will say that there was at least one bill that was true insurance reform, and I think it passed.
It did.
And that is that the insurance companies cannot, moving forward, pass on the cost of their advertising to policyholders.
Yes, thank God.
And so that may work, and the rates may go down because of that, as opposed to the tort reform stuff. I want to talk to the first person who goes to trial on their case, and they're found to be 51% at fault in the accident, and they get zero recovery. That's the person that's going to yell and scream and say, what happened? This is not fair. But it's happening. It happened this year.
And that's what we're trying to, and that's what we're trying to scream to get people's attention, because talking about tort reform is boring. But when it happens to you, and medical malpractice, we're the poster child for tort reform. We've been reformed since 1975. I mean, we have the reversionary trust, we got the cap, we got the panel system, we've got it all. And we have the worst healthcare in the country. We don't, all the crisis there is a crisis. We have terrible healthcare here. We have the most 1-star, 2-star nursing homes. I mean, it hasn't gotten better, and it's not going to get better because that's not what was causing it to begin with. So I hope that people will listen to this and listen to, because I know that through LAJ, you do a lot of work protecting, plaintiffs and the people really from having their rights stripped away. So I thank you a lot for that.
Well, it is a joy to do that. And I will continue to do it as long as I'm breathing. I will say this too, this notion of, especially in a state with a cap as restrictive as ours, unadjusted for 50 years, it's also created a haven for bad doctors from other states to come here. And no one talks about that, okay? But that's on the uptick. I've lost count of the number of cases against the neurosurgeon in Shreveport.
And the general surgeon in Lake Charles.
Correct.
Yeah.
And they came here because it was not a favorable environment for them in their states. And so they came here so that their mistakes would cost them $100,000 of insurable recovery, and then they could keep practicing. And then the next victim would happen shortly after that. So that's part of what's driving why we have bad medical statistics and medical data in the state. It's because we do have some doctors that are coming here with not the best intentions.
You're so right. I've sued the doctor out in Lake Charles and the neurosurgeon, so I know exactly who you're talking about. I think they have to report. I think the state knows who they are because they had to report themselves because they've paid out that many times. But anyway,
Right.
I wanted to say something that has now slipped my mind. Oh, here's what I had for you, and it's a good segue to bring this to a close. So when we were at the legislature this last time for the nursing home bill, one of the representatives asked an attorney, why is it that medical malpractice lawsuits would have anything to do with helping reform healthcare in Louisiana? Why does that make it any better that a medical malpractice suit could be filed and they could get more money? That question was not posed to me, and I wanted to chew my arm off because I wanted to answer it so badly. But what is the connection between medical malpractice lawsuits, right, and healthcare and what's acceptable? I mean, there is a major connection there, right?
Yeah, I haven't studied it, but I can just say this, that if the goal is to improve medicine and medical outcomes, then challenging the providers to provide better care, more timely care, provide care that's consistent across different races, genders. Everybody gets the same care. You don't get crappy care if you're in the rural setting, and you get better care if you're in a city. Everybody gets the same care because we're delivering good health care. You're going to get better results, and people are going to be happier, and they're going to be more productive, I think. And so it's a trickle up as opposed to a trickle down. Everything, if we are healthier and our recovery, we don't have to recover from a bad outcome, or our recoveries are quicker, we're back at work, we're productive, and that helps everybody across the board, I think.
Also, there's a component of having to take accountability for these big medical institutions, which, by the way, I'm an Ochsner patient. I've said it before on this podcast, and I'm not pointing any fingers, but for these big institutions, let's say that the fix costs $1 million to fix whatever problem they may have, or they could continue to pay $100 each time they got a violation. They're never going to fix that problem, are they? They're only going to continue as a company to keep putting a Band-Aid on it, right?
Well, the numbers people would say it doesn't make sense to do it.
Exactly.
You would hope somebody's heart would tell them fix the problem and spend the money. Bigger is not always better. I think being bigger allows for maybe some newer technology to be introduced where it wasn't available before. Sure. But you also have to invest in the people that are properly trained to operate that new technology.
That's exactly right.
To get good results. Having a robotic arm surgery suite is great, but you got to have somebody that's skilled to do surgery in that way, or you're going to have bad results.
And not someone that's coming over from Vermont with 8 lawsuits in which he's killed or catastrophically injured patients. A doctor who has a nice record that is moving to Louisiana to help provide care because we're a great place to live and can be a great place to live.
Yeah, and we've been in transition. I mean, Look, old general surgeons in Louisiana, they were not trained with laparoscopic surgery. They had to learn it at a seminar after they were in practice because patients were demanding that. And now we're seeing it again with the robotics and all of this other stuff. And guess what? AI is going to start impacting healthcare, hopefully in a good way. I hope so. Well, I'm getting the signal to wrap it up.
So, Ben, thank you so much for being on the show. And in case anyone wants to get in touch with you, I always tell people if you have a medical malpractice issue, please go to a medical malpractice attorney, and you are one of the best. So can you tell people how to get in touch with you?
Sure. My office number in Baton Rouge is 225-344-3555. And my email is ben@mgmattorneys, and that is plural.com.
All right. Well, thank you so much, Ben. I hope we make some difference. I hope we can get some full and fair compensation for victims in 2026.
We certainly are going to keep up the good fight. Thank you, Sarah, and tell Chip I said hello.
Oh, I will.
Thank you for listening to Bayou Justice. I hope today's episode has given you valuable insights into the complexities of medical malpractice in Louisiana. If you'd like to learn more about our mission or get involved in our advocacy efforts, please visit patientrightsla.com. Your support can make a real difference in the lives of patients across our state. Remember, together we can create a fairer, more just healthcare system for all Louisianians. This is Chip Wagar, and I'll see you next time on Bayou Justice.